Good morning, everyone, and a big welcome to all who are able to join us live this morning or this afternoon if you've joined us from Asia to talk about e-signatures today and how to get it right. Today, I'll be joined by two of my fellow Field Fisher colleagues to discuss e-signing. And before I introduce them, this session will run for about 30 minutes with time for questions at the end. You'll find that there's a Q&A or question box on your screens, and do feel free to submit your questions as we go. We'll take them all at the end. The other thing to say is that we'll be recording the session, and we'll make sure to share a recording with each of you afterwards so that you can share it with your colleagues. So today I'm joined by Richard Gibbard and James Lewis. Now, Richard is a professional support lawyer in our finance team and of counsel. So he tends to be the person that we all go to with those annoying technical questions. And we're seeing those questions coming in thick and fast on e-signatures right now, which is why we decided to do this session. James Lewis is a partner in our dispute resolution team, and his clients tend to be banks, corporates, or high net worths. And he deals with anything from contractual issues to shareholder disputes, and generally is a troublemaker. So we go to him when things go wrong, and he's also seeing a lot of thorny dispute-related questions on e-signatures. So with that, we're going to turn off our cameras during the presentation, but we'll turn them back on at the end for the questions. And with that, over to you, chaps. Thanks very much.
Thanks very much, Tim. So before we jump in substantively, I'll just say a few words about what it is that we're likely to cover. And I should imagine that most of you listening in today will be here because of the increased chatter around electronic signatures and the logistical problems we face in obtaining and exchanging traditional wet ink signatures on documents, both here in the UK and internationally. A lot of that chatter has focused on the legal effect of electronic signatures, but we've seen and heard less on the practicalities and the pain points that electronic signatures themselves bring. With that in mind, this webinar will look at the execution of documents in a transactional context and provide a deeper insight into how to sign contracts electronically, the problems to avoid, and some tips for overcoming a few of those practical difficulties. This webinar comes somewhat hot on the heels of the Law Society of England and Wales having updated its 2016 guidance on the use of virtual execution and e-signatures in response to the COVID-19 pandemic, and we've incorporated some of that guidance in our content today. At the end of the presentation part, we should have time for questions and answer session, as Tim mentioned, should you have any specific queries that we haven't covered. So to start off with, and because we're lawyers and we can't quite get away from the law altogether, I'll just say a few words on what we mean by electronic signature, how that might differ from virtual signatures, and what the legal effect of those might be across different jurisdictions. And also, because lawyers love exceptions, this webinar will not cover the execution of wills, which are subject to more specific requirements. So let's start by looking at what the difference is between virtual signing and e-signatures. Virtual signing means signing a hard copy paper document in wet ink and then circulating a scanned version of that document, or just the signature pages, in an electronic form by email. Now, I'm of a generation of transactional lawyers that remembers the late night gatherings around vast boardroom tables with piles of documents to sign. But the reality is that for some time in the UK, the majority of transactions have completed on the basis of the Law Society's 2010 practice note and the so-called Mercury protocol, which I'll talk more about later. Many other jurisdictions around the world also accept the signing and exchange of documents on a virtual original or sort of PDF. Now, it's worth saying that this virtual form of signing and closing is still very much effective and feasible, but it does require parties to have access to printers and scanners and the capacity to generate and disseminate often large and complex documents. If you think about the full suite of documents in a construction or project financing context, for example, it's unlikely that many homes will have that kind of printing and scanning functionality. Electronic signing comes in effectively as a subset of virtual signing. Before we talk about the extent to which electronic signatures are legally valid, I'll just expand on what we mean by them. In simple terms, electronic signatures are where we use technology to dispense with the need for wet ink as a form of execution. In the EU and the UK, electronic signature has been defined for the best part of a decade by reference to the 2016 EIDAS regulation, which superseded earlier UK legislation. Under that regulation, an e-signature is where data in electronic form is attached or associated with a document in electronic form, and that data is used by the signatory to sign. It's a common misconception, perhaps, that e-signature is limited to e-signing platforms such as DocuSign or Adobe Sign. In reality, an electronic signature may take many different forms. These include a signatory typing their name or initials at the bottom of an electronic document, such as an email, or in the signature block of a Word document, a scanned handwritten signature that is incorporated into an electronic document, or pasting an image of a manuscript signature, such as a JPEG, into an electronic document, clicking a confirmation button on a website, using an instrument or a finger to apply a mark on an electronic document via a touchscreen or a digital pad, or obviously using a web-based e-signing platform like Adobe Sign to generate an electronic representation of a handwritten signature, or a digital signature using a sort of cryptography backed by a digital certificate from that platform verifying the signatory's identity. Now, in understanding the various forms that e-signature may take, it's important to consider how trustworthy, secure, and reliable the technology used to create it is. For example, just typing a name into a Word document is very easy to forge. Also, anyone who has access to an image file of a manuscript signature might just paste it into a document. So it becomes important to distinguish between the legal validity of an electronic signature and its evidential weight. So that is, while an electronic signature may satisfy a strict legal requirement for a document to be signed, and it's admissible in evidence in legal proceedings, the parties also need to consider the extent to which that signature might still be called into question if there is a subsequent dispute concerning the authenticity or integrity of the document. Having an enhanced quality of electronic signature can demonstrate the integrity of the document, effectively denying it has been tampered with or changed, the authenticity of that document, ensuring the document comes from a particular person or source, and non-repudiation, so that a signatory is prevented from denying that they signed the electronic document. Digital signatures, which are more technologically advanced and secure, aim to address some of these evidential issues. Under the EIDAS regulation, there are 3 tiers of electronic signature: a simple e-signature, the advanced electronic signature, and the top tier qualified electronic signature. A qualified electronic signature, which requires enhanced identity proof and a certificate issued by a qualified service provider, affords the highest level of admissibility in EU courts and has the equivalent legal effect of a handwritten signature. Also, a qualified electronic signature that is based on a certificate issued in one EU member state will benefit from mutual recognition across the whole EU. Specifically in the UK, up to this point, qualified electronic signatures are largely unused because they really work better and are more readily understood in EU countries where there's a national ID scheme. In England and Wales, the distinction between different tiers of electronic signature is somewhat redundant, as all types of signature are valid. The question, as I say, is more one of the evidential standing of that signature. In Scotland, there's a clearer use case for qualified electronic signatures and advanced electronic signatures, particularly in property transactions. E-signing platforms will generally provide the option to sign by way of a digital signature with different degrees of encryption and authentication technology in order to meet those EU standards. So if the burning question for you has been, are electronic signatures valid? The answer is yes, and the law's not changed since the outbreak of the pandemic. As a general rule, they're legally valid and admissible in the UK and the EU, as well as most of the major jurisdictions around the world that deal with commercial contracts. The key thing for an electronic signature to be valid in England and Wales is that the signatory enters or applies their e-signature with the intention to authenticate the document. If the signatory does that, then the law says the e-signature has the same legal effect as wet ink, but you'll still need to meet any other signing formalities, for example, witnessing. So where there are exceptions to the validity of signatures, these typically come down to certain document types that require these additional formalities, some of which we'll touch on shortly. There's no additional need to sign a wet ink or hard copy version unless that document needs to be registered in that way, which again I'll come to, or where it needs to be notarized or apostilled in other jurisdictions. At a cross-border level, and looking first to the EU, the Rome I Convention tells us that it's a question of the contract's governing law as to whether a party has validly signed. So if a French company has signed an English law contract, it It is a matter of English law as to whether that e-signature is valid, and the signature will be valid provided the French company is permitted to execute documents in that way as a matter of French law in terms of their capacity and authority to do so. In Europe, and as I've already alluded to, there is an increased focus on the type of electronic signature that is applied. So if your governing law is French, German, or Spanish, for example, you'll need to be more aware of what it is that needs to be signed and the particular requirements under that local law. So just to showcase a few other key jurisdictions outside of the EU, under New York law in the US, virtual signings, e-signing platforms, and JPEG signatures are all okay, but there are some exceptions for certain documents. The story is broadly the same for major economies in the Commonwealth countries, such as Canada and Australia. In Japan, virtual signing, e-signing platforms, and electronic signatures are all thought to be valid, although they are relatively untested. In China, virtual closings and e-signing platforms are generally okay, but JPEGs might be a problem, and there are certain documents and transactions that still need wet ink versions. Again, in all instances, it's likely that courts around the world will assign different degrees of evidential weight to different types of electronic signature, and this will depend on the facts and process by which the signature is generated and applied to a document. So returning to more familiar shores, I'll just talk briefly about some of those additional document formalities that might come into play. The first hurdle you might come across is where there is a legal requirement for a document to be in writing and signed by a relevant person. Now, happily, electronic signatures will work in England and Wales for documents in this category, such as guarantees or a legal assignment. The nuance in e-signing really comes in when we start to think about particular document types. Indeed, one of the reasons why e-signatures haven't been adopted wholesale in England and Wales is because of a reticence around electronic signing deeds in particular. Under English law, a deed is a document that is executed with a high degree of formality. There are particular circumstances where deeds are required by statute or common law, such as registrable transfers of land, mortgages, appointments of trustees, powers of attorney, and agreements where there's not sufficient consideration. It's also partly the reason why we've excluded wills from this webinar. In its 2019 report, the Law Commission of England and Wales concluded that an electronic signature is capable in law of being used to validly execute a deed, which itself may be electronic, provided the person signing the deed intends to authenticate it, and any applicable formalities relating to the execution of that deed are satisfied. Those same formalities must be observed irrespective of whether a deed is executed with an electronic signature or a wet ink signature. Now, for most practical purposes, the formalities we're talking about here are witnessing. Now, although authority is nuanced depending on the circumstances, the Law Commission, in their review, take the view that a witness has to be physically present to observe the signature. Separately, the Law Society, in their most recently updated guidance, have stated that it remains best practice for the witness to be physically present when the signatory signs, rather than witnessing through a remote video link. However, they do accept that with public health restrictions in place, it will not be possible to follow best practice, and it may be necessary to modify practice to suit the current circumstances. Now, HM Land Registry's view is that it would be unsafe to accept any form of witnessing other than contemporaneous physical witnessing as being sufficient effectively for the purposes of Section 1(3) of the Law of Property and Miscellaneous Provisions Act. So where does that leave us? Well, firstly, a virtual signing and an electronic signature can validly be witnessed by someone who is physically present. The law doesn't prohibit witnessing of electronic execution, and the witness can also electronically sign their attestation and need not actually sign it contemporaneously while they're in the presence of the signatory. E-signing platforms have built-in systems that purportedly ensure the witness is physically located, for example, but they're not infallible, and it's not always possible to verify that the witness was physically present and observed the signature. E-platform functions might rely on a party opening a document on the same physical device, for example, or on the same network using IP addresses and the like. But these technical solutions still have the potential to be masked or manipulated in some way. There are also other problems for larger transactions in terms of separating out those documents that need to be witnessed from those that don't, and so on. These methods all still require a physical presence, of course, but returning to that requirement, are there any practical solutions for witnessing when social distancing prevents close proximity? Well, there are a few. So first, consider who can be a witness. The only legal stipulation is that someone who is a party to a deed or who receives the benefit of it should not witness. But can a spouse or relative, even a competent minor, sign?
But because he or she may be required to give evidence as to proper execution by the signatory, it remains advisable that an independent witness be used. Secondly, can you somehow arrange for a witness to take place with suitable precautions? For example, placing documents 2 meters away on a driveway or a doorstep, taking turns to sign using masks, gloves, and separate pens. Thirdly, can you dispense with the need for a deed altogether or sign in a way that doesn't require a witness? And finally, can we stretch the case law to accommodate a video link with a clear line of sight and ancillary evidence? Effectively, you'd be running a test case in these circumstances, but some may take the view that the pandemic has changed the landscape enough that a public policy exception might be made. Now, as a brief aside, recently in Australia, the state of New South Wales pushed through a law expressly permitting video witnessing. However, no such legislative fix has been proposed for the UK. Another aspect to consider is the need to register or file certain documents. The need to register documents in some instances has also had an effect on the speed at which electronic signatures have been adopted. That is, certain registries have insisted on wetting signatures before they will register the documents. Some of those requirements have relaxed in recent years and months. For example, Companies House will now accept a certified copy of a charging document executed using an electronic signature in satisfaction of the registration requirements under the Companies Act. But that's if it's using the online web filing service. If you're still filing in paper form, you'll still need at least to certify the document in a wet ink form. Also, Companies House has indicated that it will not accept a simple typed signature in a document, which is actually slightly at odds with what the Law Society guidance says that font or typescript forms, for example, will be accepted. Unfortunately, therefore, there's still some confusion as to the extent to which an e-signed document or form will be accepted by Companies House in every instance. And the advice is really, if in doubt, seek confirmation that your proposed form of signature is going to be acceptable for filing. HM Land Registry and the Land Charges Registry require a wet ink signature on a paper version of any document that's submitted to them for registration. However, the Land Registry have recently indicated that they will accept deeds that have been signed using the Mercury virtual signing approach, which again I'll expand upon in a moment. Where stamp duty is payable on a document, HM Revenue and Customs would normally expect to stamp a version of the document with a wet ink signature. During the pandemic, however, HMRC has relaxed some of its requirements to allow PDF signatures. Now, while lawyers may be seen in some circles as static, if not obstructive, it's worth highlighting that law firms across the country have come together to discuss and coordinate responses to some of these registration and filing conundrums, and we've been encouraged by the collective efforts of the industry in that regard. So how does an electronic signature work? If we're saying that the law hasn't changed, why are we focusing more on it? Well, plainly, the current pandemic, social distancing rules, and the lockdown have put a spotlight on the ability to conduct non-face-to-face transactional closings as traditional processes are unable to continue. Now, given we're not returning to physical closings anytime soon, we must all consider virtual execution, including the use of e-signatures, as the new normal for completing transactions in a timely manner. And that means we have to understand the practicalities as much as the law. So what does a virtual closing or e-signing look like? Well, we've already alluded to Mercury a couple of times. Mercury closings are those that follow best practice protocols derived from a 2008 case known as, unsurprisingly, the Crown and Mercury Tax Group against HMRC. There are actually 3 options for virtual closings, but in the interest of time, I'll mention option 1, as that covers the full range of agreements under English law, including deeds. Under option 1, a signature page will need to be signed and witnessed in pen and then captured with a scanner or a camera to produce a PDF, JPEG or other suitable copy of the signed signature page. A law firm typically sends out the relevant documents for signing to parties with clear instructions based on that protocol. Each party then signs and sends a single email to their solicitor attaching the final agreed copy of the document and a copy of the signed signature page. The idea is to reduce problems with post, paper and scanning, as it will enable parties to email deeds and other documents to their client or customer, who then only need print and sign, and witness if needs be, the signature page and take a photo or scan of that before returning it for completion. What about using electronic signatures? Well, as with all things, the key is preparation. If electronic signing is proposed, the parties and their advisors should agree the relevant method and platform, if any, to understand the detail of the signing process as early as possible ahead of completion. It's advisable for a coordinating law firm to agree and circulate signing and release instructions that follow Mercury protocols wherever relevant. If using e-signing platforms, be aware that they're not fail-safe. They need to be set up properly and with good transaction management discipline to get things right. You can still make legal mistakes with e-signing platforms, from automatically adding date stamps to signatures to signing in the wrong order or circulating the wrong documents to the wrong parties. E-signing platforms have various account options. It may be the case that the coordinating law firm has an e-signing account, or it may be the case that the client holds the account. The choice will often come down to policy. Check there are no restrictions on e-signing, for example, in a signing company's articles or other constitutional documents, as well as any internal policies for any party using e-signing, such as risk management. They might still need wet ink forms or require e-signatures to be channeled through a suitable encryption and identification technology. In a finance context, for example, you may also need to give thought to specimen electronic signatures and how these are held or reproduced for future transactions. Given the technical limitations of reproducing exact copies of handwritten signatures in an electronic form, PDF scans of wet ink signatures may not marry up with the electronic signing process. So if your transaction is a cross-border transaction, local lawyers will still need to be consulted in each jurisdiction as to any restrictions. So assuming all that's teed up, how does an e-signing platform actually work? Well, typically a coordinating law firm at your reputable law firm of choice organizes for the execution versions of documents to be uploaded to the platform, together with instructions as to how to access the document using email addresses. Documents may be packaged up and disseminated in a virtual envelope. There can be limitations as to document sizes. We've heard issues, for example, with vast building contracts with their multiple schedules of plans and drawings, requiring them to be chopped up into smaller packets. Also, there are concerns in some instances that documents need to be witnessed, assuming you're comfortable with e-witnessing, are sent out to the witness alongside documents that they are not required to witness. So there can be confidentiality and privacy concerns here. It's crucial to understand who has what access and permissions in relation to the documents you're packaging. But assuming you can set up the envelopes to work for your transaction, the next stage is ensuring the person you send them out to is the right one. The main advantage of an e-signing platform is security, particularly as to identifying and verifying signatories. Platforms are mostly cloud-based and encrypted. So typically the coordinating lawyer arranges for a secure passcode to be generated by the platform to be pushed to the signatory, which gives them unique access to the documents uploaded. The platform will use metadata generated by these processes as an evidential breadcrumb trail should it be required, and a certificate of completion is generated for each transaction, which sets out the document history on the platform, recipients, access, when the signatures were added, and where, using location identifiers such as IP addresses. The coordinating party can set the order in which the documents are signed, and dating also needs to be strictly controlled. It's important that signatures are not automatically date or time-stamped where there are specific legal reasons why that document is not dated, released, or delivered until an agreed time. We recommend that if there's an option to time or date stamp documents, that function is deactivated and dating is left to the coordinating party. Finally, once all e-signatures are applied, the coordinating party is notified and the parties agree that the dated original document and certificate of completion is then retained by the law firms acting on the transaction, together with all the other transaction documents. The history of the signing process is typically recorded and viewable, should it be required. And as I say, this audit trail may also be helpful for regulatory compliance purposes, particularly in regard to data protection, accountability, and data retention obligations under GDPR. What about electronic signatures not using an e-signing platform? Well, keeping your electronic execution within the bounds of an e-signing platform has the benefit of consistency and the encryption and security they offer. However, as we've heard, electronic signatures can be applied in many ways that are also legally valid and are not limited to those offered by the likes of DocuSign or Adobe Sign. Again, we're in the realms of evidence, integrity, and authenticity. So a document signed by pasting a JPEG image of a signature into a document and returning it via email is plainly more susceptible to fraud, or perhaps more benignly, mistake. So execution in this way should also take place following an agreed process. Again, a reputable law firm should take charge of coordinating the signing, and additional checks can be put in place to require written confirmations from the signatory that they inserted their signature into the relevant document and intend to be bound by it, and then supporting authority by way of board resolutions, for example, that the signatory was authorized to sign in that manner and acknowledge their intention to be bound. Given the multiple avenues for getting documents signed, it's perhaps reasonable to ask if it's possible to have a mix of signing formats, that is, e-signatures, virtual signatures, and wet ink. Well, English law, typically accommodating, allows that, but certainly, again, from an evidential perspective, not least a logistical one, it's advisable to consolidate signing methods as far as possible. Indeed, there's also a view that where a certificate is issued by an e-signing platform, if it only pertains to one counterparty, while others have signed off platform, the certificate rather loses its evidential value. Additionally, it may not work for cross-border transactions or where a registry requires it, because all the signatures need to be in one document. So to the extent we haven't already mentioned them, what are the other potential issues that can still arise with e-signing? It's fair to say that technology does provide us with solutions to the logistical problems of hard copies and posting wet ink signatures, but what if you don't have a suitable printer or scanner? In the absence of a printer, electronic soft documents can be e-signed in various ways, either by clicking, inserting a preloaded manuscript image, using a stylus, or simply typing in a font. An email can also constitute an electronic signature. However, where this is done through an e-signing platform, there are obviously more safeguards as to the authenticity and integrity, as we've talked about. Another tip, if you don't have a scanner, is that a photo image is no less effective. There are some common sense practical tips here, though. Ensuring the document is well lit, that you can capture the whole of the document and the signature, including any footers, so page numbers and document reference numbers and the like. When circulating those images, you should also follow Mercury instructions in the same way as if you were using a scanner. It's also worth making the point that some institutions don't actually like their documents being stored or circulated on personal devices like mobile phones, so care has to be taken in some regard there. Interestingly, when we look at electronic signatures in terms of evidence, in the good old days of wet ink signatures, we made or make a lot of assumptions around authenticity and integrity of execution. In the world of e-signatures, we're actually provided with additional levels of metadata and evidence to unpick, and a process that's supposed to assist actually ends up, in effect, creating more problems. We should always be alive to those methods that allow the least capacity for mischief and build processes and protocols that mitigate the chances of things going wrong. We can get comfortable that a range of e-signature or virtual signing methods are effective at law, but there'll be different degrees of resilience to fraud. And for this reason, certain methods may be more problematic on a cross-border level. So what else should you be mindful of? Well, aside from verifying identity, which again I'll talk about in a moment, you should check the authority and capacity of the individual signing. There should be clear evidence that the parties have the capacity and authority to e-sign, and that they're also happy for counterparties to do so, whether that be by getting sight of board resolutions and approvals, or by relying on due diligence as to the absence of any relevant restrictions in the entity's constitutional documents. Be aware of the relevant logistics and the need or otherwise to follow a particular method. Is there a particular reason why a person might be eschewing a more secure digital signature and actually want to proceed on a pasted in JPEG or a simple TypeScript signature? Are there ways in which you can bolster the factual matrix around a transaction, perhaps by observing the e-signature separately over a video link, getting a separate email confirmation from the signatory that they did in fact e-sign a relevant document? And where witnessing is required, a confirmatory email that they were physically present and observed that the signatory e-signing the relevant document, and have subsequently inserted their own signature into the document. So turning now to security, be aware that e-signing platforms, as well as transaction management platforms, where documents might be uploaded as part of a closing, they're frequently cloud-based. Now, for the most part, organizations now are comfortable with cloud-based solutions, but you should still check this is not a problem. Picking up on specific concerns as to ensuring the identity of signatories and the recipients of any documents that are to be signed, there are a range of views as to the effectiveness of various authentication methods, such as two-factor or even three-factor authentication. There are different ways to achieve this, and much will depend on the platforms and the participating parties' approach, but for the most part, they will require the recipient to use additional passcode keys to access the documents rather than simply receive them by email. This information will typically be sent to a mobile device, and recipients would be asked to confirm the relevant details to the lawyers coordinating the signing. In that sense, these arrangements are still not infallible, as they necessarily rely on the parties providing accurate and truthful information. The flip side is that, as I've said, this additional data provides an admissible audit trail should something go wrong. What about the status of an electronic original document and requirements for certified copies? Well, since the Mercury case, English law recognises the concept of a virtual original document. That is, an electronic version. It does not need to be in hard copy or wet ink to be an original document. Indeed, you can have multiple versions or counterparts, some of which are wet ink and some of which are electronic. It is, in our view, possible to certify an electronic document as an original. However, it will depend on the history of that document and how comfortable the certifying party is as to its origins. Another point to make is to check the policy of any e-signing platform as to how long the documents remain stored on that platform and can be accessed or investigated after completion, should the veracity of that signing process be called into doubt. Another question we're asked is if we need to amend the document to allow it to be electronically signed. Now, generally, there's no need to include express provisions referring to or consenting to e-signatures, but there are some circumstances where it will be necessary, such as older documents that may expressly exclude electronic forms, or in jurisdictions where it may be helpful from an evidential and certainty perspective on advice from local counsel. We do advise that signing instructions and completion arrangements expressly contemplate virtual signings, and that these can be widened to contemplate specific e-signature forms, including e-signing platforms. And we're aware that some organisations that operate their own accounts on e-signing platforms include specific wording that requires customers to consent to the use of electronic signatures before they're able to sign using the platform. And finally, legal opinions. Legal opinions from most reputable law firms won't typically require amendment for virtual signing, but some firms will amend these on a case-by-case basis to include certain factual assumptions around e-signatures. Often this will be as to matters of identity and so forth, which are typically matters of fact and not something that lawyers are expected to opine on. That being said, a legal opinion will ordinarily talk to the capacity and authority of the signatory, so the recipient can get some comfort in that regard. Okay, so that was all I had to say. I think we're going to move now to a question and answer session, which I think, Tim, you might want to take forward.
Absolutely. We can switch our cameras back on at this moment, but Richard, thank you very much indeed. That was really helpful, and actually quite a lot of information in there to be gone through. So I think quite a few people will want to listen to this again afterwards. But we've got some questions coming through, which is fantastic. Let's take the first one from Mariam Jom in Singapore. Richard and James, will a link be sent to participants of the recording of this webinar? The answer is, Mariam, yes, it will be. We will make sure that we'll send a link to all of those who have attended, and we'll give you the chance to follow up with specific questions offline. Next one, would it be possible to circulate? Yes, indeed. Yeah, same question. So other than those two, whilst we're talking, do feel free to send through further written questions using the question chat section. But I've got a couple of my own. It seems to me that the main thing here is one of organisation, and those of the lawyers in the room are obviously familiar with virtual signings. We've been doing those for years. But normally we just follow a closing agenda, which has a list of the documents and a list of the signatories. I think, having listened to you, Richard, is it worth doing a dress rehearsal even, or going through and being specific about not just who's going to be signing, but how they're going to be signed, and going so far as to say, you know, who's going to be witnessing and in what capacity and where are they? Something that I've never contemplated doing in the past. I've always let clients find their own witnesses.
I think that's a great idea. I think generally there are, as we said, you know, on a simple level, yes, an electronic signature is valid, but there are lots of ways where you can sort of trip up, and I think there are mistakes that can be made. And actually, some of these electronic signing platforms, as much as they like to be, are sort of a bit counterintuitive, and some of the sort of methods in terms of setting up can be quite technical. So certainly doing, you know, setting it all out in a very sort of granular level would be quite useful. I'm not sure how much appetite there would be for doing a dress rehearsal for these things. I mean, you know, maybe some of these transactions are completing at a slightly slower pace in lockdown, but certainly if there is a scope to sort of work through some of these issues beforehand, that would be, you know, very much advisable.
Thank you. I mean, we tend to find that I quite often get asked, I'm in a hotel, there's a director in a hotel somewhere remote, and you know, can they use a security guard or someone for a witness? I think if people are all doing this from home, it's going to be a bit more challenging. Is it okay for spouses, children, parents to witness your signature?
Yeah, I mean, yes, as I say, as I said in the presentation, the only sort of legal stipulation really is that the person isn't a party to the deed or doesn't have the benefit or an interest in that deed. So yes, you know, you can effectively have a spouse or and even a child, provided that they are sort of a competent in that sense. So I mean, it does get a little bit woolly around there, but there are options, but you do just have to be mindful of, if this signing is going to be called into question, effectively you are then going to have to get that witness into court to confirm. So that's the sort of thing that you need to be mindful of. But yes, there is no sort of general prohibition on a spouse or a close family member witnessing, but you know, try and keep best practice in mind.
Thank you, Richard.
Yes, if I could just add in there, Tim, I think you've just got to remember what the role of the witness is. The role is to witness that a signature has been applied, and then also to attest to it by adding the witness adding its own signature. But in terms of actually witnessing a signature, I think people do sometimes forget that the category of people who can act as witnesses is actually rather wider than a lot of people think. There are some clear exceptions. For example, if you have, you cannot have your signature witnessed by another party to the same deed. There's also other particular documents, for example, wills, where there are more stringent requirements. For example, there need to be two witnesses to a signature. But subject to that, the question really comes down to what will be the strongest evidential support to the signature. And that's why best practice has always been to have a rather more independent witness, i.e. someone outside of the close family, and somebody perhaps with more of a sort of recognized standing, whether it be professional or otherwise, just so that if there is to be any question in the future, the evidential burden can be relatively easily dealt with by contacting that person, hopefully someone of relatively good character, and the question of bias doesn't come into play because that person is pretty removed from the signer. But I think in these times, it is worth remembering that if a document is to be signed by you and your wife or other close relative who's currently locked down in the house with you has no interest in the document, no personal interest, they are a perfectly good witness.
Thank you, James. That's excellent. Well, this takes me on to my next and favourite question, which I'm very pleased to see that Paul has asked. When it comes to witnessing deeds, did you say a witness can witness by video or FaceTime link and physically witness when in possession of the document? I'm going to let you guys answer that because I know how I've answered this question in the past.
As a disputes lawyer, it is my bread and butter is these kind of rather gnarly cases that throw up situations which you probably wouldn't have created even in fiction sometimes, but they do come up, and that's why and that's how the case law is created, because the situation comes up that hasn't really been dealt with before. I think where we are on this is that the best practice remains that physical presence of a witness is the best practice. The reason for that is that the law is struggling a little bit to deal with how to deal with virtual witnessing, virtual signing in general. It all stems really from first principles, which is the requirement for deeds to be witnessed comes from a 1989 Act. There's no actual specific reference to it, to the presence of the witness being a physical presence, which has led people to think, well, can it be stretched to a virtual presence? However, the Law Commission, in its latest report, has come down on the side of the fact that witnessing should be physical, and any video or virtual witnessing may not fulfill that requirement. So they are sitting a little bit on the fence there, but they're kind of playing the conservative role on this. Now, this hasn't also been helped by some case law. The case law, going back many years actually, has generally come down on the side of physical presence is what's important. And that goes back to the idea that the basic idea was a witness would do their job as a witness by being physically present to a signature, and at the same time, the second part of the witness's job, attesting to that signature by actually putting their own signature in there afterwards to say, yep, I confirm that this happened. The old cases talked about things like documents being signed and then attested at a different time. Some even years later, people were trying to claim that the attestation should still be valid. Those have generally been rejected. However, in recent years, there has been more cases looking at whether virtual witnessing could be accepted. And with the speed in which things are changing due to circumstances, I think there will be more cases coming out on this. I mean, the most recent case I'm aware of involves actually two parties based in Hong Kong signing a document that required witnessing. One of those parties was in Hong Kong. It was witnessed by video link by their solicitor in London. The court actually, and the court did actually find that that was a valid attestation. Now, there has been some criticism of that case because it's not in line with some of the, the statutory requirements and as interpreted by the Law Commission. But what it highlights is that this is an evolving area, and it may well be the case that the requirements and demands of the current continuing situation may see a shift in the law to more acceptance of virtual signing. But I think what needs to be made clear is that there needs to be some kind of support to try and verify the virtual signing. So we talked about protocols, we talked about dress rehearsals, we've talked about the idea of working out in advance who is going to be doing the signing and who is going to be witnessing. If that is all laid out, that also provides quite valuable evidence to suggest that a certain person was going to be witnessed by another person. And if that happens in the document, then it all seems to add up.
Yeah.
So
I think it's effectively taking Mercury the extra mile.
I think it is. I don't know if Richard, you have anything other to add on that.
Yeah, I think so. I mean, I think, you know, like I say, you've sort of talked about these cases, and there have been other cases, you know, going back to people sort of witnessing documents through carriage windows and line of sight and all this kind of thing.
My favourite case.
That's it. Yeah, but you have to remember some of these cases were sort of done a lot of it was in the context of wills, and there's particular mischief there around, you know, sort of life planning and things like that. There's a sort of public policy reasons why wills and things would need this kind of veracity. So people are sort of talking about, well, is there a public policy argument that now we have the pandemic, and we also have a much more advanced systems of technology, that really you can start to sort of, certainly on a commercial contracts level, work around that. And I think, you know, it was encouraging in that sense that when the law was changed in New South Wales recently, that, you know, they did recognise that actually this is a sort of concept that needs to be addressed, and they did it quickly by, you know, not waiting for a test case, just putting a sort of statutory amendment in. So if you were going down this remote witnessing route, there's no doubt you would be something of a test case. But there are sort of, there's some thought there. I think the other point just to mention on that is that actually getting to the point where you need a remote witness should be relatively, scarce, because there are, as we sort of talked about, there are other options. That there aren't too many circumstances where you can't get your spouse to witness, or you can't get your neighbour to witness by keeping sort of 2-meter distances. And we've seen these.
I was going to say it should actually be easier in a sense now, because people are more likely to be signing from home. But let's just rattle through a few other questions, because there's quite a few that have come through, which is fantastic. You mentioned 2 meters there, and obviously social distancing needs to be observed even when witnessing. We've been asked by Amina, mentioning witnessing 2 meters apart. Can this be done by way of counterpart, i.e. the signatory signs one copy of the document from his front door and the witness watches it at a safe distance and then signs on her copy?
I think, James would probably know the case law on this a bit more, but I think the understanding is that the witness should be attesting on the same document. But I think, we've sort of seen practical solutions to that in terms of someone signing a document, walking it out, leaving it on their car bonnet, and then someone coming over and collecting it. Again, keeping surfaces separate, with gloves and documents being sealed and things like that. There are sort of practical ways of doing it that you don't necessarily need to sort of run the gauntlet of doing things in a sort of contrary way.
It's going to be challenging to merge together a counterpart with a witness and a counterpart with a signature. I agree. I think we'd prefer to see it on the same document if at all possible. Richard, you mentioned New York was generally okay with e-signatures. Is there a different policy across all US states? That's a tricky one from Pierre. And we haven't got any New York lawyers on the phone today, have we?
No, I mean, I picked New York because that's the one that we sort of most often deal with in the financial context. What I will say is a bit of a plug is that that we have an electronic signing opinion portal which you can log on to if you're a member of the International Securities Derivatives Association. You can get access to that, and that sort of covers 37 jurisdictions. Now, generally, the US is pretty similar across its main sort of commercial jurisdictions. So we'd be talking about California law, Delaware law, and things like that. The principles we would expect them to be the same. I can't talk with absolute authority on it, but I would be relatively comfortable that e-signatures are broadly acceptable in most of those jurisdictions, with the usual exceptions for wet ink in some instances.
That's great. Thank you. Any advice or tips when a counterparty insists on applying local law requirements for your company's signing authority? An example Adriamo has recently, he experienced a Chinese customer insisting on 2 directors and or a witness to the signature, despite that being a requirement under local law for a UK registered company. Sorry, despite that not being a requirement under local law for a UK registered company. Maybe I can take that one.
I think it really comes down to the law of the document and to what is a valid form of signature for the purposes of the law of that document. I mean, we have in England and Wales, if you have an overseas company signing an English law document, then there are sort of there is sort of established law as to how that overseas company should sign, and we do accept in some instances that effectively what is the sort of customary form of signature in that jurisdiction. So I think you do sort of need to get into the nuts and bolts of what is the governing law of the document.
And again, I think laying out in advance how it's going to be executed and by whom tends to solve some of these last minute questions, and that's what causes the stress in transaction when someone deviates at the last minute. But generally, if someone's insisting that there are 2 directors executing a document, providing you've got both directors available, I rarely have a problem with that, as long as you've got sufficient signature boxes for it, or it starts to look a mess.
Can I add one more point on that, which is whilst I know that there are many documents which do require the witnessing requirement, it is also worth for commercial agreements, just considering whether you do actually need to sign the document as a deed.
Yeah.
Just to avoid any of these witnessing problems. I mean, as a very last resort, of course, you should remember too that an agreement that might be attempted to sign as a deed, but is not validly signed as a deed, is still a binding agreement.
Yep.
And remains so. It just doesn't have the ultimate full protections of a deed. For example, the limitation period for bringing any claims is 6 years for a simple contract rather than 12 for a deed. But it's one of those where you could save yourself some headaches if there are documents which simply don't need to be signed as a deed.
Yeah, and obviously
we're always big. Sorry, Richard, carry on.
I was going to say, when we talk about witnessing with companies, you know, most companies will have 2 directors, and if you're signing with 2 directors, you dispense with the need for a witness anyway.
Correct.
So we're talking about sort of, you know, companies with sole directors or whatever, where you need witnessing, or you're having deeds being witnessed by an individual. So yeah, I think you once you sort of start to narrow the categories as to whether or not you actually need a witness, and then does that witness really need to get to be, you know, a remote witnessing, you're really getting to a very small category of executions, I think.
Let's just move on to, we haven't mentioned JPEGs yet, but we've been asked by Marta, with JPEG signatures, is it important who inserts the JPEG into the document, or can a person other than a signatory do that for the documents to be validly signed?
James, do you want to say this? And I think it's really one of sort of authority, isn't it, and understanding the authority of the person.
Yeah. Now, well, actually, this does go to an interesting point, which is the fact that an electronic signature, to be a proper e-signature, needs to be both the signature with the intention to authenticate the document. And what I mean by that is that there needs to be in a way the ability to link the signature, the e-signature, to the person who is purporting to put it on the document. Now, that might sound relatively straightforward, and in most situations it is, but there has been a few cases about situations. For example, there was one case where a company was facing a winding up petition. The director of the company which was facing this asked someone else, one of his employees, to send a response back saying, look, please don't do this, we'll do this personal guarantee. It was sent off this email, but there was no reference to the individual, and the only sort of link to the individual who was purportedly giving the guarantee was an automatically included email address through the server. This was held not to actually be a binding agreement. Now, it's a fairly extreme situation, but I think what it highlights is that where you're dealing with any kind of e-signatures, which are not through a portal, if you're using just sort of a signing and scanning process, which of course is perfectly valid for an e-signature, it would be best practice to make sure that the person doing the signing is then the person sending the document, in order that there is an absolutely clear link between the document being signed, the person having signed it, and the person sending it, so that it all adds up.
No, that makes perfect sense. Another question here from Laura. Thank you for this question, Laura. Is it a good idea to amend or include a clause to expressly say the parties agree to execution using e-signatures? Currently, most of my contracts authorize virtual signature, so I was just wondering if also including or replacing this with e-signatures would give it more protection.
Yeah, I think the thing to say there is it's not a requirement, but if you have the opportunity to do it and the parties are happy to include that, then it does help. I mean, as I sort of said,
it helps from an evidential perspective, doesn't it?
It does, and particularly on a cross-border. On cross-border transactions, you may see that it's. I think we've heard some sort of anecdotal evidence that it's actually quite common now in Spain, for example, to include that kind of wording. And also one of the things I sort of mentioned was that some of these e-signing platforms, we have one particular client that set their e-signing platform up with this sort of express language at the start of it that you have to sort of click through first to say, you know, we agree to to execute in this way. So I definitely think it's worth doing, and it just you know, it just sort of makes, it provides certainty and clarity, and that as lawyers is what we absolutely want. So
certainly what we tend to do is, and I know you do it in the finance team, you have detailed board minutes that lay out the authority for directors and how they're going to execute. I think it's important to go the extra mile in that particular resolution at board meetings now to include authority to sign by e-signature.
Yeah.
Let's see, what else have we got here? We've got a few more minutes. Do you see much value in adding boilerplate warranties with respect to the authenticity of the signatory?
I don't think we necessarily have to go that far. I mean, I think that you do get to the point where you sort of start to we're questioning so much, because when you think back to a sort of wet ink signature, we just didn't ask.
You've got the same issues. Exactly. Yeah, but evidentially it's the same problem, isn't it?
Exactly. And I think that's one of the things that people are sort of getting a little bit distracted with. And it is true that obviously with electronic signatures, there's a lot more to, as I say, sort of unpick. You can sort of go back and say, did that person get the right email? Did that person, is that the person who got the passcode for their authenticity? And all these kinds of things. There's a lot more metadata for you to look at and investigate if you're going to try and sort of debate the veracity of that signing, which you just don't have with wet ink signatures. Yeah. So you do have to take a lot more on spec with wet ink. Now, that's not to say we necessarily need to go back to those days, but I think some of the anxiety around electronic signatures is, I wouldn't say unwarranted, but again, you just think about, is this a mischief that we really need to sort of address in the document?
Based on the latest question being debated, in a jurisdiction that expects every page to be initialed, presumably that needs to happen on e-signatures as well. I think DocuSign and most of the platforms allow for initialing of pages, and you just have to make sure that you tag each page for initials accordingly, don't you?
Yeah. I think that is there are particular idiosyncrasies with some jurisdictions on that thing, and unfortunately some of them are unavoidable. But that again comes down to sort of preparation and diligence ahead of time to work out what you need to do and whether the process that you're using will actually accommodate those requirements.
I think we've got time for one last question. Is one party able to sign electronically and another party using a pen physically? So wet ink from one, or virtual, I guess, would be the case, virtual and e-signature at the same time.
Yeah, I think that is possible. I think again, you are sort of slightly introducing the potential for there to be sort of mistakes, if not doubt, in the execution, particularly if you have, say, for example, a document being signed by two directors. One of the directors signs at home on an e-signing platform, and the other director signs by pasting in their JPEG in their house. That you are sort of slightly saying, well, why was it done that way? Why didn't both directors sign up to the e-signing platform? Why didn't they both paste in their JPEG? It's just sort of, you're just introducing potential for doubt.
Yeah.
So I just think,
and actually the usual problem is I haven't got the ability, I haven't got a printer at home, so I can't print and sign and scan. It's actually generally easier to use DocuSign on one of these platforms. So insisting that everyone downloads it and uses it is probably the way forwards.
Yeah.
Listen, chaps, we're out of time. Just a very quick thank you to all of those who joined us today and asked all those fabulous questions. James, Richard, thank you very much indeed. We'll share with you a recording in due course.
Thanks so much, everyone. Thanks for joining.
Bye for now.
Bye.